It is my greatest hope that by the time you finish viewing this presentation, you will come away with the confidence that every aspect of my claim on the issue of fraud, the issue of the impact on my health, by asking that you believe that every aspect of the defendant's claim has been all a complete and total lie. I'll also be able to show you how the defendant's attorney has been involved in keeping this lie covered up. Everything that I have, photographs, video footage, statements, medical records, everything is verifiable. Everything is absolutely truthful in what I have said, just as it is truthful in the claim that I am making. The defendant and his attorney, not to mention started this mess, Mr. Fane, have all been aware of the lie they've been telling and trying to sell that lie. When you submitted your initial letter requesting that they provide proof of purchasing a used engine, Mr. Phillips responded, and on his cover letter, he had already given himself away. He claimed that I had never provided him any evidence proving that the engine hadn't been replaced. He also went on to say that it was difficult for him to take my complaint seriously. It was clear from the very beginning that he was going to be a wall that I would not be able to climb. He decided that he could be judge and jury, deciding the merits of what I had to say, deciding any relevant did see the evidence. He went on to tell me how I ended up driving my vehicle as though he was there, and then they claimed that it had to do with the part or parts that was the reason that the engine had failed. But Mr. Phillips went further, because he then chose to become personal and attacked my character with some of the statements that he made in that letter. I didn't believe that an attorney would have the authority to say the things that he has said or to make the claims that he has made. And he truly insulted me to suggest that I was attempting to extort money from his client. It made it clear to me from reading his letter that he was not going to allow anything to get past him, at least with me. They wanted statements from my mechanic, and especially they wanted to see the serial number from the engine. For someone to suggest that he did not take my complaint seriously, it's incredible that they threatened to sue me for defamation. On the invoice of the cover page that he sent, it shows they claim that a used engine was purchased from D&M Used Auto. It suggests it was a Toyota 2200 RE engine. Shows the purchase date of September the 15th, 2011. When the defendant recently submitted their supplement discovery, they point out the 15th as a date where they claim I had appeared at their garage, and that's when I supposedly watched them install that engine. But it would be difficult to imagine how they could have installed that engine when they claim in a letter that they had thoroughly tested it. If they picked the engine up at 12:20, they closed at 5:30. It's amazing they would have had the engine thoroughly tested and then on a hoist and lowering it when they claim I came to their shop. They said I could have gotten the engine if I'd paid the core charge, and they claimed that that core charge is what their supplier charged them. But when they provided the invoice from D&M Used Auto Parts, it shows that they turned in the Toyota engine on November the 22nd. Again, they point out that it's a Toyota engine, and they say it's for a credit of the core charge. The defendant will need to explain the $150 difference. They submitted invoices from O'Reilly Auto Parts, showed the purchase of axle and CV boot. This purchase was on September the 19th, 2011, as well as from Napa Auto Parts, again the CV boot and the axle. And that purchase was also on September the 19th, 2011. The defendant shows a host of labor that was done, 6 different things by one individual. How will the defendant explain how one mechanic was able to perform 6 different jobs on the 16th of September and have all of those jobs completed by 1:43 in the afternoon, which is reflected on the invoice? Let's take a look at what's been said so far. The defendant claims that I had only wanted 2 repairs. And they made that statement all throughout everything they've claimed. In one of the letters, he pointed out that the axles and CV boots were not something I wanted. And he claims that it would have cost me more than my budget would have allowed. And he used past tense, may have wanted, but they showed that they put them in. Intake and exhaust manifold gaskets could not have happened. Not only did it not happen, those boats were seized. The defendant claims that on the 8th of August, 2011, they said the vehicle was brought into their shop to begin the repair process or procedures. And they also claimed that day they installed a new battery. That's a picture of the battery that was in my vehicle. Based on the condition and the strap that was on it, that should have caused the vehicle to fail the inspection. The signal light, it never happened, and no document or any other letter prior shows the manifold gaskets or the turn signal. They explained that the battery was in such a bad state that they had to put a new battery into my vehicle on August the 8th. But that's not all they claimed, and you don't see that anywhere else, but it is in that letter. On top of the new battery they claimed to have installed, they also claimed that they installed a new oil pump. Again, looking back at the 8th of August, 2011, they claimed that the vehicle had been brought in, and that is when they had began the repair procedures. But interestingly, in the defendant's claims that had been sent in their response, they said the vehicle was brought in to their Bay Area on August the 8th, but it wasn't for the repair procedures. They said it was for an inspection. I think we can ask the defendant a lot of questions. Here are some ideas I have. the new battery. The term has now been changed to new blemished battery. The defendant claimed to have installed a new oil pump. There's nowhere that you'll find that claim other than in that initial letter. Claims made prior, you won't see those claims made, nor will you see the turn signal that they claim was installed. The defendant claims that it was when my vehicle showed up that Mr. Fain identified all of these issues. And in that follow-up letter to their initial response, I challenged them about that claim because I know that for them to have been able to find the issues with the brake lines or master cylinder, they would have had to go under the vehicle and under the hood. Defendant responded back, and you'll see that in the letter marked as attachment A. They didn't mean it was upon delivery of the location. They meant when it was brought into the shop area. The whole issue about the missing lugs and lug nuts and all these things, the brake lines, all these things the defendant claimed had to be done before the vehicle would pass a state safety inspection. Looking at the defendant's response, where they claim the labor was performed on the vehicle, there is nowhere where you'll see anything showing the labor for installing missing lugs or lug nuts, or even an invoice to show those parts were purchased. Let's take a look at some of the things the defendant said so far. We can prove that what they sent is a VIN number. I was able to verify whether or not a Pontiac engine would fit in a truck. The defendant should know the difference between a VIN number and an engine serial number. His lies about no complaints ever being filed, there are 5 online. This one here is online. He had to respond, so he cannot say he didn't know. To suggest that Mr. Fain was management only, then why would the defendant claim in one of his letters that Mr. Fain personally test drove my vehicle? The defendant has tried their absolute best to point the finger at me to suggest the U-Haul trailer I was towing was too heavy for the vehicle. The interesting question that should be asked is, how would the defendant possibly know the contents inside that trailer? I had a lock on that. This is a copy of my son's bank statement, which shows that a total of $906 was taken out of his bank account on September the 19th, which is in fact the day that we picked the truck up. Mr. Phillips has been very much involved in protecting his client. And this is just another example of how the defendant is doctoring their story as they go. It's amazing that my neurologist gave me a clear bill of health only so that it could turn around in short fashion and completely be destroyed. All the documents I've given you, I'm sure there are multiple copies of the same thing, and it is overwhelming. This is the condensed version. The fact is the defendant has lied from the very absolute beginning. You can see it now. You can see those statements. You can see the statements that his attorney has made. Can an attorney say the things that he has said to me? Can he decide what is relevant in my complaint? Can he decide whether or not my complaint is something that should or could be taken seriously? Can his attorney suggest that he knew what exactly caused my vehicle to break down and how I was driving it, how I over-revved the engine, or how I drove it so harshly, how the trailer that I was pulling that was closed with a lock, that they were convinced that it was full? Everything they've said has been to A, point the finger at me, and B, to take any blame away from themselves. The defendant and his attorney have destroyed 3 years of my life, and the future of my health has and will forever be diminished as a result of their actions. Please, for God's sake, you see what's happened. Now that you see this, I know that anybody, if anybody, can do anything to finally end this nightmare for me, it is you.